Welcome everyone to Deschutes Public Library's online programming. Before I introduce tonight's speaker, just want to let you know that we have so much really great informative content on our YouTube page. So if you're looking to learn something new, anywhere from pickleball instruction to Puerto Rican food cooking classes, please visit our Deschutes Public Library's YouTube page. We have a whole bunch of great content out there. So I'd like to introduce tonight's speaker, who's going to be talking about the Second Amendment and how it's the history of it, how it's evolved, and where we are now with the Second Amendment. Before coming to Bend, James Foster was chair of the Department of Political Science for 12 years on the Corvallis campus. He is a founding faculty member of OSU-Cascades, moving to Bend from Corvallis in 2002. He taught courses on constitutional law, administrative law, gender and law, and American political thought. He has published articles on legal education, book chapters on affirmative action and equality debates, as well as on the Oregon Judicial Branch. So I'd like to welcome Dr. James Foster, a very dear friend. I'd also like to welcome our ASL interpreter, Ms. Norton. So Jim, take it away.
Thanks, Liz. I'm glad to be doing it again, even if we have to do it virtually. And thank you for our ASL interpreter. We really appreciate your efforts in helping to make this accessible to more people. So, Second Amendment, where do we start? One thing that occurs to me looking at you all, your charming faces coming up on the screen, is how many remember a 1960, 1970 television show called Hollywood Squares? Remember that, where celebrities would sit around in squares and they try and do tic-tac-toe by answering silly questions and winning prizes. Well, this is sort of like Bend Squares, if you want to put it that way, except our task is much more significant than trying to stump the host. Ironically, even though in Hollywood Squares everybody is in a box, I'm hoping to encourage us to think outside of our particular box when we get to talking about and thinking about the Second Amendment. Because frankly, the Second Amendment is highly fascinating, but also very complicated. It has a long history in Anglo-American jurisprudence. It plays a significant role in our own jurisprudence in the United States. And it's not easily, what do I want to say, is not widely accepted in terms of the way in which the Supreme Court has interpreted it. So I'm going to try and explore some of those complications by way of framing a discussion that we'll have. We'll pick this up at about 5:45, I guess, right, Liz? Okay, good. Okay, I suggested that we try and think outside of our Hollywood square boxes. There's another term that I'd like to introduce, and it's from Chinese architecture. It's called Feng Shui, F-E-N-G S-U-I. Any of you ever heard of Feng Shui, what it is and how people work with it? Okay. In architectural design and interior design, Feng Shui means basically aligning the objects in a room in which creates harmony in that room. I'm suggesting that we do some intellectual Feng Shui with regard to the Second Amendment. And what do I mean by that? I mean, basically through conversation and talking and thinking about the ideas that are pertinent to the Second Amendment, we can align our own understanding and perhaps our shared understanding of the Second Amendment. So unlike Feng Shui, which seeks for harmony, we're seeking for a more perfect union. That language might sound familiar to you. It's from the preamble of the United States Constitution. It's the first line of the Constitution, the preamble. We, the people of the United States, in order to form a more perfect union. What I'm suggesting is intellectual Feng Shui toward the goal of attaining and living in a more perfect union. That language was repeated, if you recall, during the inauguration of President Biden by a wonderful woman named Amanda Gorman. This is her book of the speech she gave. Here's one of the lines from Amanda Gorman's speech. Somehow we've weathered and witnessed a nation that isn't broken, but simply unfinished. What I'm suggesting is that we engage in intellectual feng shui toward the end of a more perfect union and perhaps moving down the road of finishing what the framers started when they launched us on this great civic experiment. Okay, so you may be asking yourselves at this point, this is all well and good, but what about guns in the Constitution? What does feng shui and Hollywood squares have to do with the Second Amendment to the Constitution? Well, hang on, bear with me, we will get there. Basically, what I want to say next and suggest for your consideration is that the two terms, guns and Constitution, are not monolithic. They, in fact, are subtle, sophisticated, and involve many different elements. And what elements are emphasized depends on what the person understands as guns in the Constitution. For instance, you've heard of the science fiction writer Kurt Vonnegut. At one point, Kurt Vonnegut was talking about the prevalence of what are called Saturday night specials, small, easily accessible, deadly weapons that are used in most crime in major metropolitan areas. Kurt Vonnegut said that Saturday night specials have only one purpose. That gun has only one purpose, and that purpose is to put holes in people. Well, that's one definition of a gun. There are lots of other definitions of a gun. What I want to suggest to you is that there is no single, all-encompassing idea called gun. The gun, the idea, and part of the controversy, frankly, entailed by the Second Amendment, is that this notion of gun is all over the place, and there's not a whole lot of agreement about what guns are and how we should deal with them as a society. Another stark example, we've just watched the Tokyo Olympics, and one of the Olympic events is sharpshooting, where a rider on a horse mounted with a rifle tries to score points by hitting a particular target. That's an eloquent, if I can put it that way, elegant, an elegant and sophisticated and highly structured way of using a gun. Now, to contrast that probably as starkly as I can, the use of a gun in Olympic sharpshooting is 180 degrees, perhaps more, removed from Adam Lanza's killing of 28 people in Sandy Hook. That was a gun. He had 3 guns, but the gun was tied to the crime. The gun was tied to the tragedy in a way that the gun used by an Olympic medalist was entirely in a different universe. What I'm trying to get you to think about, again, Feng Shui, what I'm trying to get you to think about is that there is no set given definition of gun, and what one thinks about policy toward guns is largely shaped about how we feel or what we think about these items themselves. What about Constitution? The Constitution can be seen as in a couple of lights. First of all, it's an operating manual. If you read through the articles and amendments to the Constitution, you learn the way in which American government is supposed to work, the rules by which American government operates, the sorts of branch, the sort of responsibilities given to each branch of the government. So, what's the Constitution? Well, one could say a Constitution is a roadmap which tells you the way in which the government is supposed to operate. Another definition of the Constitution, it is a statement of principles and values. When you talk about, say, due process, as we will in just a few minutes, when you talk about due process, that is a value that has a long lineage, a very, very long lineage, which we'll talk about in just a minute. The Constitution itself can be seen as a statement of principles and values hammered out and fought for and died for over many, many centuries. So again, my point is that we need to open up our minds to the possibility that there's more than one thing called gun and more than one thing called Constitution that is in a variety of circumstances. One other point.
My bad, Jim. There you go. Okay. So you're.
There
you go.
Okay, we back?
Yeah.
Okay. Real estate agents have a rule of thumb called location, location, location. If you want to understand what factors drive the prices of a house, you have to understand the way in which where the house is built and the neighborhood in which it's built interact to create a price. Well, you can say the same thing with regard to guns and the Constitution and the Second Amendment. What does the Second Amendment mean? Well, to put on my lawyer's hat, a hat that annoys a lot of people sometimes, the answer to that question is it depends. What is the Second Amendment? Well, it depends on the circumstances and the context within which you're going to discuss it. Most fundamentally, due process in the Constitution is a protection from arbitrary governmental action. In other words, the due process clause, which underlies the Second Amendment, holds that government has to play by the rules, or at least ideally, government has to play by the rules. But of course, all those terms, playing, rules, abide, are fundamentally controversial and subject to debate. So a lot of people have different ideas about what is due process. So let's take a short, brief, I hope, trip back through Anglo-American history. Excuse me. I tell my students that you can understand most of Anglo-American Constitution history with a triangle. I don't know if you can see that very well. Hold this up to me. Here's the triangle. You can understand most of Anglo-American history in terms of a triangle. Doesn't matter where you put them, but the three major players are the Catholic Church, Parliament, and the King. And hundreds of years of English history were devoted to fighting out among these three major players what the government's supposed to do and what the government can't do. It's almost 800 years. If you take the starting point is 1215, which I'll talk about in just a minute, and take it all the way up to a case in the Supreme Court that you've probably heard of called DC versus Heller in 2008. If you start with Magna Carta and go to DC versus Heller, you've got about 800 years of these three institutions fighting it out over which is going to be supreme. Real quick overview. 1215 is when King John, sidebar, there's only been one King John in English history, and that's because he was such a lousy king, lousy from the point of view of the landowning class. They cornered him in a meadow now outside of London called Runnymede, and had him sign a document. And the document was called Magna Carta, or Big Chart, if you will, in English. And that chart laid out a series of actions that the king forswore and wouldn't do, and his commitments to certain protections for the landowning or baronial class. And one of the key guarantees that King John agreed to, of course, he signed it and then immediately began to ignore it. And the war between he and the landed gentry continued for many more years. That's beside the point. The point is that he signed this document, and chapter 39 of Magna Carta says that the king will not go against or harm or otherwise penalize his subjects. I wasn't talking about every subject, he was talking about primarily the landed gentry. The king will not go against or harm or otherwise punish his subjects except, and this is the key term, per legem terra. That's PERLEGEMTERRAE. Magna Carta was in Latin. Translating per legem terra, that means according to the law of the land. Now, what is so significant about Magna Carta is not that John ignored it and essentially began to violate it before the ink was dry. What's important is that that phrase, according to the law of the land, is one of the bedrock principles of the rule of law in the United States as well as in England. What's bedrock about it, as I suggested a few minutes ago, is that the government must play by the rules. Think about the Due Process Clause. It says that the government, in Amendment 5, in the Fifth Amendment, it says the government may not deprive any person of life, liberty, or property without due process of law. Two thoughts. Due process of law is the same thing as per legem terra. Secondly, that means that the government can take your property, can take your liberty, can take your life, as a matter of fact, so long as it does it lawfully. And what that means is that so long as the government abides by certain rules and does not act arbitrarily. We'll see this as we go down the road here toward 2008, when Mr. Heller basically said to the District of Columbia government, your law saying I can't take a gun out of my house or keep it in my house for self-protection arbitrarily deprives me of my liberty to keep a firearm. Now that language in DC versus Heller traces all the way back to 1215 and Magna Carta and per legem terra. There are other greatest hits. I'm looking at my notes in the time. There are other greatest hits that we can point to. 1649, Charles I was beheaded by the parliamentarians, headed by Oliver Cromwell, and in a pretty definitive way established the superiority or the supremacy of Parliament over the king. Prior to 1649 and Charles I's execution was another powerful statement of the rule of law, which came from Henry VIII. Yes, it's that Henry VIII with multiple wives, well, he was an interesting guy. What was interesting for our purposes is he went up against the Catholic Church, and in 1532, essentially dispossessed the Catholic Church, threw them out of England, took over all the monasteries and churches, and established himself as the head of not only England as king, but also head of the Church of England. Yet another milestone, if you will, Magna Carta, the accession of the disposal of the Catholic Church by the then king, and then the parliamentary supremacy with Oliver Cromwell. One more, and we'll move along. One of the most famous English jurists is a man named Edward Coke, spelled Coke, but it's pronounced Cook. He was Lord High Chancellor of the King's Privy Council, and he spent most of his life locking horns with James I, because James I believed in something called the divine right of kings. That is to say that here on earth, kings reign supreme, and they are only accountable to God after death. Well, Sir Edward Coke said, you've got it all wrong, Your Majesty. The king himself is accountable to the law, and to the people, and to Parliament, and not to some abstraction called God. So what you see here are milestones along the way from 1215, moving along 800 years to 2008, which essentially developed the core notion of the Second Amendment. And the core notion of the Second Amendment in due process terms is that the government may not deprive a person of their right to keep and bear arms. That's the language in the Second Amendment. The government may not deprive any person of their liberty to keep and bear arms unless they do it lawfully. Again, that word lawfully means play by the rules and not act arbitrarily. And so what the court has basically done in the modern era, in the Supreme Court of the United States, is to try and sort out where the parameters of due process exist with regard to keeping and bearing arms. Excuse me. So, fast forward to 1939. We haven't gotten to 2008 yet. Fast forward to 1939. There were a series of 4 cases between 1939 and 1975, all of which involved guns and the Constitution, all of which involved interpreting the Second Amendment of the Constitution. And all of those cases, in all of those cases, a government regulation governing the use of and keeping of firearms was held to be a collective right. Now, here we make a crucial turn that's important in understanding the Second Amendment. All 4 of those cases, basically the plaintiffs in all 4 of those cases challenging various laws regulating firearms, argued that the government acted arbitrarily in taking away the law. In one case, it was a sawed-off shotgun, for instance, in taking away the arms or regulating the arms of individual Americans. The plaintiffs replied, were arguing that the government was acting arbitrarily. There's that word that goes all the way back to 1215 and Magna Carta, when the king said, "I will not harm my subjects except according to the rules of law." Well, in 1939 and the other 4 cases, basically what the plaintiffs were arguing is the government acted arbitrarily. They were not playing by the rules when they tried to regulate or to take our guns away from us. But note this, the Supreme Court of the United States in all of those cases held that the Second Amendment does not prohibit the government from taking or regulating those arms. Why? Because the government essentially understood the Second Amendment to be a collective right. Well, here it gets a little dicey and a little picky, so I'll try and make it as clear as possible. From 1791, when the Second Amendment was adopted, until the early 1930s, there weren't any cases. There was no litigation around the Second Amendment. It was there in the Constitution, right? It's here in the Constitution. It's there in black letters on white paper, but it wasn't contested. It wasn't litigated. There was no controversies that led to an argument that the government was acting arbitrarily in taking a person's arms. When it finally got to the court in the late 1930s, what the court held was that these laws regulating firearms are not a taking. They do not deprive the individual plaintiff from life, liberty, or property without due process of law. Why? Because the Second Amendment only pertains to collective rights. Now, this is where I say it gets a little complicated and even more controversial. What the court held in all of those cases was the government regulation was not a violation of the Second Amendment because the government was only affecting individuals, and the Second Amendment right is tied to a collective right. What that means is the right of an individual to keep and bear arms depends on the individual's participation in a well-armed militia. That's the other language in the Second Amendment. Basically, what the court held in all of those cases was the Second Amendment does not prohibit the government from regulating individuals' arms because the right to keep and bear arms only pertains to membership in and participation participation in an armed militia. So now we're on the threshold. We're in 2008 in a case called DC versus Heller. As I've indicated, the District of Columbia law prohibited people from keeping firearms at home or going out of the house with a loaded fire weapon, which is armed. Mr. Heller sued the District of Columbia, saying that law deprived him of his Second Amendment rights to keep and bear arms. And for the first time in 800 years, almost, for the first time, the Supreme Court, by a vote of 5-4, Anthony Scalia, writing the opinion, stood the original interpretations right on their head and said that this right articulated in the Second Amendment is not an individual right, not a collective right, but rather an individual right. And they upheld the lower court's overturning of the regulation. So there's really only one more piece of the puzzle, and then I'm going to try and wrap it up here. 2 years after DC versus Heller, there was a case called McDonald versus Chicago. And that case essentially followed the same path, walked down the same road as DC versus Heller 2 years previously. The crucial difference is that McDonald was suing the city of Chicago. And the reason he could do that is because of another very, very significant, perhaps one of the most significant amendments to the Constitution, the 14th Amendment, adopted after the Civil War as part of 3 amendments, 13th, 14th, and 15th. 13th abolished slavery, 14th guaranteed due process and equal protection, 15th guaranteed the right to vote, all right? So those are crucial, aptly named Civil War amendments. The 14th Amendment had a due process clause almost identical to the 5th Amendment's due process clause, with one crucial difference. The 14th Amendment said no state can be deprived of any life, liberty, or property without due process of law. Now, why is that significant? I'm going to have to take a bit of a short detour, but I'll try and explain it. In the 1830s, when John Marshall, the great John Marshall, was Chief Justice of the United States, there was a case called Barron versus Baltimore. John Barron was a shipper, a very, very wealthy and a widely established ship owner in the city of Baltimore. The city of Baltimore decided they wanted to do some civic improvements, which involved dredging one part of the harbor and dumping fill in another part of the harbor. Long story short, the fill raised the bottom of the harbor. John Barron could no longer get his ships in the port and dock them. He essentially was put out of business. So he sues the city of Baltimore, saying that their law or their civic improvements had deprived him of his property without due process of law, and moreover was a taking of his property. Now, let's be clear. John Marshall was sympathetic to John Barron, who unfortunately died before this litigation was completed, and his estate, his heirs, carried on with it. But John Marshall was very sympathetic to John Barron's complaint that the city of Baltimore had basically put him out of business. But here's John Marshall. I sympathize with you, my friend, but there's nothing the Supreme Court can do to protect you from this taking, this deprivation of property. Why is that? Well, the reason for that is that the 5th Amendment, under which John Barron was suing, only applies to the national government. As John Marshall said toward the end of Barron versus Baltimore, that while he sympathized with the plaintiff, he was powerless to provide any remedy, because the 5th Amendment of the Constitution only applies to the general government, that's to say the national government. Fast forward to 1868. Remember the 14th Amendment? 14th Amendment contains a due process clause just like the 5th Amendment, except it applies to the states. So after 1868, in a process called incorporation, which we don't need to get into this evening, right? Through a process called incorporation, gradually, incrementally, on a case-by-case basis, the Supreme Court of the United States took the individual protections of the Bill of Rights and applied them, i.e. incorporated them, against the states. So when McDonald's sues the city of Chicago, he is doing so under the authority of the 14th Amendment, which includes the guarantees of the Second Amendment against the states. It basically converts the specific Bill of Rights protections into due process protections and applies them against the states or municipalities or localities. So, recapping here very briefly. What you've got in the last 800 years, if you're a little breathless, I can understand. What you've got in the last 800 years is the development of due process in a way that ultimately incorporates the Second Amendment into protection against states and localities, and also involves individual rights, not collective rights. Those are the two key moves. Individual right to keep and bear arms, protected by the 14th Amendment, as incorporated in 1868. Okay, let me take a short sip here. Here's how I want to close. I want to close with what I call Foster's 3 C's, which is designed to complicate your understanding of the Constitution, but also sophisticate your understanding of the Constitution. When we talk about the Constitution, we're really talking about 3 different constitutions, hence Foster's 3 C's. There's the written or textual Constitution, the document, right? Here it is. You'll see it in the National Archives. It is a written letter, word-by-word document that resides in the National Archives. That's the written Constitution, capital C. You can add to capital C not only the language of the amendments or the document, you can add all of the judicial decisions that have interpreted that document, such as DC versus Heller and McDonald versus Chicago. Second Constitution is what I call the lowercase c, or the cultural Constitution. The cultural Constitution is what animates, brings to life, energizes the written Constitution by providing a floor of values and beliefs and commitments that Americans abide by and embrace. Lastly, the third C is constitutionalism. Constitutionalism is not a thing. That's not an object. It's an activity. It is a political activity through which the capital C Constitution is interpreted and modified in ways that are in accord with the lowercase c values and beliefs. Now, the best statement, that can be a little abstract. So probably the best statement of what a constitution lowercase c looks like is a book controversially entitled How the South Won the Civil War. This is by Professor Richardson, and she's fascinating, engaging book. But the reason I wanted to read to you, part of it to you, is because she quotes an 18th century English politician by the name of Edmund Burke on what he calls manners. Now, as I read this to you, think of manners as the underpinning of the cultural constitution. In other words, the cultural constitution is an articulation of the manners that underlie American politics. It's not all that long. Bear with me. Manners are of more importance than laws. Manners are what vex or soothe, corrupt or purify, exalt or debase, lift up or refine, by a constant, steady, uniform, insensible operation, like all of the air that we breathe, and do not know is there. So, one of my favorite illustrations of the cultural constitution is a school of young fish, curious and interested, was swimming in the pond and wanting to know what water was. So they finally found the wise old fish who had lived for years and asked the wise old fish, "What is water?" And the wise old fish said, "You're swimming in." It was invisible. It was taken for granted. And it was essential to their life force. Same with the cultural constitution. It is that set of manners which energizes the Constitution, capital C, and it's the terms by which we play out our constitutional politics called constitutionalism. So, how are we doing for time? Almost at 6:40, Liz.
Good. Are you ready to move into the Q&A, Jim?
Sure, anytime.
Okay, so I'm going to stop the recording and thank you very much, Jim and Ms. Morton, for being here tonight to put together this great program. I'm going to turn off the recording and then invite any questions and answers. So thank you.